All right. I'd like to introduce our speaker. He is from Sioux Falls, South Dakota, and went to Washington High School. His name is Eric Hansen, and he was my classmate, one of the very smartest people in my class, for sure. Eric got his undergraduate degree from SDSU, and then graduated from USD Law School with honors. He went on to clerk in the First Circuit right after law school, and then took his current position with Dakota Homestead Title Insurance Company as their corporate counsel, and also the corporate counsel for the Homestead Escrow and Exchange Company, where he also serves as the vice president. And the Homestead, or Dakota Homestead Title Insurance Company, is the only South Dakota-based title insurance company, and they service just about every county in South Dakota and handle all types of real estate transactions. So Eric is a great person to be able to speak to us today about real estate transactions, and we'll turn the time over to him.
Sure. Thank you guys so much. As Marilyn said, my name is Eric Hansen. Feel free to ask any questions as we go along. Myself and the other attorney I work with, Chris Moran, we jokingly refer to ourselves as the pro bono section when it comes to the real property part of the South Dakota Bar. That's because compared to most attorneys, all we do is real estate transactions. When it comes from either questions from our title companies, questions from attorneys dealing with our 1031 tax deferred exchanges, our sole focus is dealing with transactions in South Dakota related to the buying and selling of real estate and how to fix the problems associated with them. As we go along, you should have received a copy of this giant packet of exhibits that I think has been sent out to you. My predecessor last year, I think, had just one copy. Marilyn said, add a few more to it, so I went a little crazy when it came to adding the rest. It's a nice part when it comes to the real estate transactions. All of these documents are ones that have been recorded with various registers of deeds office. Some of them are good examples, some of them are bad examples. Hint, hint, you have a table of contents. There's some of them in bold. Perhaps that will mean something when it comes for doing your problem later, for answering them. As we go through, the other thing to notice is the fact that I'm probably unlike most of your presenters that you're going to have, and that one for running the slideshow myself, but two being significantly younger than some of them. I think it's great to have the chance to, shortly after law school, come back and help out with regards to, going through things. I think a large part of what we're going to talk about is not only drafting for real estate, but issues associated with real property law. Show of hands quick, how many of you took property? It should be everybody, right? And it was a joyful, fun experience your first year of law school where you learned a lot while you're busy studying for civil procedure at the exact same time. And how many of you are third-year law students? Raise of hands. Pretty much every single one of you. And why is that? You're going to need to know real property again when it comes back up for the bar in a couple months. So you'll be frantically trying to review what was it when we talked about easements, or what was it when we talked about surveying estates. And this is hopefully going to be a nice refresher, because when you go out there, you'll have to see and deal with all types of real estate transactions. It's not just as simple as preparing a deed between a couple going back and forth. There's any and all types of complexities associated with it. So hopefully this will be a resource for you going forward. To start out with, if we advance, things we're not covering today. First, we're not talking about wild animals. I remember that, I think it was the second week of law school, going through as to who the deer belong to under real property laws. Good news, I've never had to answer that question in all of my time doing real estate practice. Treasure troves, who finds the buried treasure chest on the property, as well as the rule against perpetuities. Thank the Lord for that one, because I don't want to spend the time talking about regulatory takings and in a domain. Pretty much all of the second semester for my property class, we focused on that issue. Quiet enjoyment, construction eviction, acquisition by fine, and good old Blackacre. I have worked hard so that all of these are real life examples, so we don't have to talk about any and all of Blackacre, Greenacre, Whiteacre, and the related properties associated with them. So, good news, last time we'll talk about that. Helpful resources when you're out there, just a quick plug. First and foremost, Got it sitting right down here. I did not know about this till I got into my job with Dakota Homestead. This is about 20 some years old. It's still the best guide out there if you're going to be practicing in South Dakota. This is written for the abstractors. The Board of Abstractors puts it out. They've been working on a new edition for, I want to say, about the last 10 years. We don't seem to make any progress, but hopefully one of these days. Anyway, even though it cites old law, everything else, it breaks down everything you would ever want to know about South Dakota law, how to handle it, how to deal with it, cites to, even if it's in the old code, where you can find in the new one, and a good breakdown as to what South Dakota case law has historically been with it. So if you're going to be doing any practice with real estate in South Dakota, I recommend trying to find a copy of this out there. It'll serve you well for in terms of analyzing issues. Additionally, the South Dakota State Bar has worked on putting together title standards. That citation there, SDCL 4330. It's Appendix A. You go onto the legislative website or Westlaw, you can find them there. Most states have this thing called title standards. They're guides for examiners, abstractors, things like that, for how they should deal with issues. South Dakota by far has the best one I've ever reviewed out there. They're not perfect. They're not always the greatest. They need to be updated in a few spots. But if you're ever coming across an issue and want some guidance as to, is it actually an issue that needs to be resolved? If so, how do I do it? Or is it something that can just be ignored because of the passage of time? The tile standards are a great spot to go. Also, South Dakota Secretary of State's website, whenever you're trying to look up anything with regards to business entities, doing fictitious name searches, UCC filings, they have a great online resource there for plugging and taking a look. Don't forget about when you're out in practice. That's particularly useful if you are working on preparing documents for a business entity that you did not set up. You need to make sure that you have the exact business entity name. Don't assume that your client is coming and telling you, well, we've got this as an LLC. Did you ever file those LLC paperwork? Is it number one? Is it the numeral number one? How do they do that? Check out the South Dakota Secretary of State's website. It'll be a great resource to see how they actually put together. All right, some common examples of real estate transactions. We're going to go a little bit quick through this first part so we can get into the more specific examples. But by now, most of you are used to deeds, mortgages, leases, contract for deeds, easements. Maybe you have some familiarity with plats, survey that's been done and turned into an exact legal description. But you may not be as familiar with the things like real estate investment trust, REITs, that they set up as an investment vehicle that they use for holding real estate. Transfer on death deeds, a new form of transaction that they just started here in South Dakota about 2 years ago, and about 20 other states have adopted thus far. Affidavits of possession, they are a phenomenal tool that we have in South Dakota that not every state has. We'll talk about them a little bit later. Or conservation easements. So there's all different types of transactions out there associated with it. Most common types of vesting you're going to see in deeds. You probably spent a week or at least a class period talking about them in your first semester of law school. You have tenancy in common. You have joint tenancy. This idea that as a joint tenant, you each equally own 100% of the property. Where do we typically see joint tenancy? Between husband and wife, that you're each treated as the whole owner of the property. Not that you have some half interest, a common misconception, but each of you owns 100% of it and can act and deal as to all 100% of the property. You also have tenants in common. That's where you own it, some undivided interest. Say that Mr. Sutton and I over there decide that we go and we buy some property, picking on him since we went to school together, that we each own it, 50% apiece. We each have an undivided 1/2 interest in that property as tenants in common. If he goes and I die, well, does he get my 50% interest right away like he would under a joint tenancy? No. It still goes down through my ears. It's divisible. It's passed down along those lines. He can mortgage his 50% interest. I could mortgage my 50% interest. The distinction between joint tenancy and tenants in common is very important when it comes to first vesting title, when someone comes into title for the property, but also for determining afterwards how they should get out of title. Good rule of thumb, your vesting on the way out always should be the same as on the way in. How do you know that? Get a copy of the deed that vests title in them. That's going to be your guide for going forward. Finally, we have this other type of interest out there, the life tenancy, the life estate, where we'd have not only life estates in for the current person, say that, dad dies, mom gets the property, but she only gets a life estate pursuant to it while she's still alive, and the kids get the remainder interest. Well, what's that interest? It's mom's life estate. It's as long as she's alive. But she can still sell that property. She can go ahead and decide to sell that interest to me, and I get an interest to lease or basically live in that property as long as she is alive. We see that sometimes. It's very much a common tactic that was used, I would say, about the 1970s on, when it comes to trusts and other estate planning vehicles that are done by some attorneys to allow mom to still have enjoyment of the farm homestead while she's still alive, while vesting title in the kids as the remainder men. Something to be aware of, because what do you need to do after a life tenant dies? You got to terminate that life estate. Even though by legal operation it's gone as of their death, you need to still record something with the Register of Deeds to let the rest of the world know about it. That's where we have for both joint tenancy and for life tenancy, the common connection there is that we have affidavits in our state that you can record to terminate the interest that people have. And unless you do that, it leaves it open as to whether or not a person has died. While everyone in Clay County may know that Mrs. Johnson passed away 3 years ago, until something's put in the record, how does that put anyone else on notice with regards to whether or not that life estate or that joint tenancy interest has been terminated? So, something to consider there. All right, just a quick review of some real property basics. Hopefully this is all a refresher with regards to it, but please ask questions as we go along. First, who here remembers talking about real estate interest as a bundle of rights when it comes to discussing for property? Remembers that discussion that they probably showed something close to that exact same picture, that you have these rights to own the land, to lease the land, to do rents, to have the minerals, all these things. Well, we talk about this bundle of rights when it comes to real estate because those are the rights inherent with owning property. It's the reason why real estate ownership is so important. You get all these rights subject to any reservations in your chain of title. That gives you all sorts of great powers that you have when it comes to owning your property. The ability for you to exclude other people off it, the ability for you to mortgage your property, to take your piece of land and get money for it when it comes to it. It's all because you as the owner of that property have those rights. So it's a key thing to keep in mind is that as you're going through, typically when you're doing a conveyance, you're conveying all of those interests, all of those rights to your successor, unless you're putting reservations in there. And if you're putting reservations in there, what are you dividing up and what's the long-term impact associated with it? So one of those common ones, right there, look at mineral estates. Oftentimes people, especially thanks to our friends up in North Dakota and their oil boom, everyone goes, I may have some mineral interest, so I need to hold that back in my deed to the house that I'm selling. Well, what's the long-term impact of that? Now we have a division of the subsurface and the surface estates. What does that mean long-term with regards to the property? And to what end? Is there probably going to be oil under your house sitting there in the middle of Sioux Falls? Probably not. So why are you doing it with regards to it? So something to really factor in. While it seems like an easy, simple idea, it creates problems down the way for people because now who has the mineral estate? Not the current owner of the property. We have to go back and find that person. And if they kept a reservation for themselves, do you think they've passed that down through the chain as they gave that to their kids, include that as an asset as part of their probate in their estate? Of course not. It's been left there. It's a hanging interest of someone who's probably long ago dead. So how are we going to deal with it? So ask yourself these questions before you're being asked to divide the estate of someone. The real property interest. To what end is it being done? And why are we doing that? And if you've come across that in your chain of title, what impact does that have? Do we need to get those interests merged back in so that we have a complete and simple fee simple title that goes with for conveying those rights going forward? It's really nice. We do have for SDCL 4313, gives us a great definition of real property. Land, that which is affixed to land, that which is incidental or pertinent to land, and that which is immovable by law. Great definition there when it comes to trying to figure out what the heck that means. It's nice though because it makes it clear. It's the first one that's the key. It's land. Land is real property. That's everything associated and tied to that land that goes with it. When we talk about improvements, we're talking about your house. Your house is considered real property. Why? Because it's affixed to the land. It's not easily movable. While I may have just about driven into a house being moving down the interstate, as I got off the interstate at South Dakota Highway 50 right there by the coffee cup, generally speaking, your house is affixed to the real estate. That's why it's considered part of the land. That which is incidental or appurtenant. When we talk about appurtenant easements in a little while, that's what they're referring to there. Something that runs with the land, that's a benefit or a right that goes with it, is going to be considered real property as well as that which is immovable by law. That category doesn't come up too often. When we talk about legal descriptions when it comes to property. A legal description is that specific description, or that specific use that's done to describe a piece of property. Why does that matter? Because that's what we convey based upon. While I may know my house is 3804, that's not the legal description. That's the commonly known address. The piece of ground itself has a legal description. Why does that matter? Because that's what our entire indexing system is based upon. The ability to have a specific name for a piece of property allows us to index it and keep those records and keep a chain of title. It allows us to put mortgages specifically against that piece of property, thus allowing someone to search to get constructive notice as to whether or not there's anything against that particular piece of property. It's been said that our system, when it comes to legal descriptions and recordings, is one of the key principles of economic development in our country. Why? Because it allows us with great certainty to know who owns what particular piece of property and everything tied there with it. And it's because we use a legal description system and a chain of title that can be done. Legal descriptions matter because they're indexed, as I mentioned before. That index is kept with the Registry of Deeds office in our state. If you go down, keep going down to downtown there to the courthouse, we can stop by the Registry of Deeds office, and there'd be a counter. Then you'd look back behind that counter, and there'd be cabinets and boxes and rows of documents stacked high to the ceiling. And while it looks like a chaotic mess as to what they have going on, each of those is indexed by a page and a book number so you can find everything tied to each piece of property. So they can go back through and someone gives them a new deed, index against everything else, and complete the chain of title that goes along with it. In our system, we typically have a few, and by a few I mean 3 different ways that we describe property. The first is the rectangular system, the section, the quarter. How many people grew up probably not in a city around the country where you talked about sales, you talked about the northwest quarter of the northwest quarter? Anybody here, Mr. Sutton, anybody else? Yeah, that's what our system was first started with. We started with this idea, as we have right here, that we have meridians with regards to how we describe property. Then we have sections that break down entire counties. And inside of each section, then we have quarters, and we have quarters of quarters and eighths of quarters. And while that's great for describing huge tracts of land that go with it, it doesn't really work so well when we get into the smaller context. Well, it'd be great for everyone to have owned 160 acres of land free and clear. Great, here you go. Here's your quarter that you're selling. That's not how we typically deal with things. Instead, we get ultimately, let's see if that works. We're switching over. Just like pause. All right. We get our cities that get started, and they do these master plats for towns. So I'm picking on Redfield, South Dakota here. That way back when, I think that this one was done, checking back through, I don't see my data. I believe when I last read it was like 1898 or something close to that. Some poor surveyor went out and set this up, where they created, according to the Say Streets, each of these individual lots and these blocks that are associated with it. And that gave them legal descriptions. So rather than being known as the northeast quarter of Section 13, this was now known as Plot 2 in Bob's edition. Mighty name that they gave it there. So it gives you some idea about how we get started. Then from there, as we go along, we get subdivisions where they take those blocks, what just looked like one square, and they divide it down to 14, 15, 20 different lots. And what do each of those lots then represent later on? Houses. This is how we get our system for where you own, someone owns that spot right there in the corner, right there on 4th Street. That's the house that goes with it. And that's where it comes from the subdivisions of the master plat that they use as they go forward. And that's how we typically get for most of our cities and towns, the legal descriptions, how they refer to it. At the same time, we have this other form after the rectangular system, after the platted system, we have meets and bounds legal descriptions. Thank the Lord, according to SDCL 43-21-1 and the fact that about 20 years ago, people decided that we really don't want them here in South Dakota anymore. They're great for describing a piece of property in that they're a vector component system. Anyone remembers doing vectors from their upper level math classes along the way, where we take the west 93 feet going at an angle of 83 degrees, thence north 14 feet. Who wants to draw that out on with their compass for drawing the boundaries of property? No one, because it's awful. It's only something surveyors would want to do, and even they despise it when it comes down to it. So when we're looking at these things and trying to figure out, we still have meets and bounds descriptions in South Dakota because you can still record and use historic ones. But if you decide today that you're going to do a subdivision of a piece of property you have to plat it. You have to call it Lot A. You can't call it by the vector description going around that old tree, starting at that stump that's over there in the northeast quarter. So be very thankful for that. You'll still see, there we go. You'll still see meets and bounds legal description from time to time, but it's something hopefully you won't have to come across too often. So as long as it's a historic legal description, A-OK, you can't create a new one. The other part associated with this is the chain of title. I mentioned it before. That's the entire history of this particular piece of property, back from patent, meaning when the sovereign, the United States, deeded this property out of its ownership down to some individual to own that piece of property. From that conveyance on, it's the chain of title of everything that has happened with that property. We have that recorded in the land record. We can follow a chain from start to finish. And if there's breaks along the way, something bad has happened. And that typically ruins my day trying to figure that out. But that's the beautiful part of it when we get to see the whole thing. An example for you. You guys take a look. Back. I like this one. I pick on one of our agents. They do a great job. They actually type out the entire chain for every piece of property that they search. That they go through and they find where it's indexed and record against and record everything. Now, most of your abstractors will do that. Most attorneys, if they're preparing an attorney's opinion, will do something similar. This shows you the chain from where we start all the way back in 1890 with regards to a final receiver's receipt to James Christian Christensen on down through the rest of the Christensen ownership, a patent that was finally issued in 1891. We can see that this one got screwed up where they started deeding the property before they technically owned it from the sovereign, but it gets cleared up in the end. These things, warranty deeds, that's what WD stands for, miscellaneous as to how it's indexed, easements that are against the property that go with it. And we further go along, you get up to 1977, you get a warranty deed. In 1981, there's a quitclaim deed. We had our prior owners, Thomas Hill and Richard Hill. I'm spending time on this because you're going to see some examples that were done later to fix a problem. In 1981, they deed this property to Israel's Covenant Church. There's a few problems with that. One, there's a notation that our examiner made. No marital status or homestead exemptions. Okay, we'll talk about that in a second. The other part, there actually is no such entity. In 1981, they deeded this property to a nullity. It did not exist. We'll have to see later how they attempted to try and fix it as it goes along with it. Then they go ahead and they go through, and we finally end up with the most recent thing back in November. They platted this particular tract of that property to create a new basic subdivision for selling to someone to buy a house, thus create a problem for trying to figure out how to fix the issue. What we also see, it referenced in there, here's an example. This is a patent that's recorded in Minnehaha County back from, this one was done 1878 is when they deeded this property out from the United States. These patents, aside from being incredibly difficult to read because they've faded with time, are important because this is what you base your entire root of title from. Someone owns this property because the prior owner, the United States, deeded it out to a private owner, and that started the chain of title. In these patents, you need to be particularly aware of the fact as to what enabling act they were done under. You'll see some reference. Typically, it's done according to like the Homestead Act of like 1864 for this time period, or another one that was done in the 19 teens. Why does that matter? Because the United States is awesome, and they said in each of these acts, we're going to put reservations. We're not going to repeat the reservations that are found actually in the patent, because that would just take too much work to repeat them all the time. So you have to rely upon the enabling act to know, such as in this case, there's reservations for, I believe, minerals with regards to what they deeded out, sand perhaps particularly in there, anything else that they could think of, there's restrictions. So knowing if you're doing an attorney's opinion, it's important to go back and find the patent and see when it was done so you can put any specific restrictions that go with it as it's tied to. In most cases now we just take a general exception to the patent and any reservations contained therein, but it's important to know what those specifically are. This one right here is another example. This one was over from Gregory County, that it was done back in 1903. I like this one, even though it was just probably a secretary who auto-stamped it, you know, had a signature there. But as you can see, in conferring hereupon, I, Theodore Roosevelt, declare that this person gets ownership of this piece of property. It's because of the act of the United States that you can own real estate because they deed it out from what they own. And it's kind of cool, the link that we have for each of our pieces of property that goes back to somewhere along the lines over 100 years ago doing this, that established it going forward from there. All right. The other cool part about patents is that middle line right there. The land patent means the exclusive land grant issued. It means that no one else owns this piece of property when they deeded it out. Now from that point on, people can and they often will try and screw up title by trying to give two separate people maybe ownership of it. But that's not always the case. By them, at the time the patent was issued, saying that only one person alone owns that real estate. And it's from there that our chain of title springs forth. In South Dakota specifically, we have our title system. The way that our title system works is that we have title plants. These are the title companies that are located in each county. We're unique in South Dakota. We're one of, I think, only about 2 or 3 states that have what's called the plant law. What does that mean? It means to have a title company, to have a title plant in a county, you must have a complete 100% match of everything that's recorded at the Register of Deeds office. So for here in Clay County, I could go to the Clay County Courthouse and look at their documents. I could go to Clay County Abstract Company and look at their documents. I could go to Meridian Title Company and look at their documents. And they will have the exact same set, every one. Most states don't have that. They rely upon someone getting an electronic copy of the Register of Deeds documents, going up there, searching it themselves. In South Dakota, if I go to the title company, it is an exact copy of what's on hand at the Register of Deeds office. Aside from making sure that you actually have accurate records and having to index yourself so you know where everything's at, it's saved ourselves a couple times. Thankfully, we've been lucky in recent years, but we had a rash from about the 1900s through the 1950s where our courthouses kept burning down throughout the state. Because of the plant law, they could just copy and take those documents over and get the Register of Deeds office back up and running. There's no missed documents that were destroyed just because of the loss of the courthouse. All right, Each plant, each title company has at least one licensed abstractor. That means that they have passed the South Dakota Board of Abstractors exam, and they are licensed to abstract title in the state of South Dakota. While we don't do abstracts anymore, we do title insurance commitments, the same skills are applied and used by the abstractors with regards to it. When it comes to either an abstract or now in 99% of cases, a title commitment being issued, there has to be a licensed abstractor who signs that, saying that they themselves, as a registered professional, have reviewed the chain of title, and this is what they have found, and this is what they're reporting on. So that's how that process works. Your Register of Deeds office is always going to be checked to make sure that there's nothing that they're missing. They double check their records that way, as well as the Clerk of Court's office. Why would you need to check with the Clerk of Courts if we're talking about real estate? I thought they just handle court cases. Anybody have any guesses as to why you have to check there?
Make sure it's not used as a judgment.
Exactly right. We index our judgments as they're docketed and properly filed with the Clerk of Court's office. That judgment is going to attach to all real estate that a debtor owns in this particular county. Thus, you get a court case against you, you don't pay your credit card bills, there's an $8,000 judgment against you. That's going to attach to every piece of property that you own, not only at the time of the judgment, but during the 10 years that the judgment's active. It's automatically going to attach to it. So, as well as the Treasurer's office, what does the Treasurer and the Director of Equalization have to do with real property? Taxes. You own real estate taxes. That helps fund our school, our roads, everything that goes with it. They are involved too to make sure as to what the current taxes are associated against it. Practice point for you. When it comes to, you go to the Director of Equalization, the Treasurer's office, they're going to have a legal description as to the taxes for that piece of property, as to how they have that marked up. Do not rely upon that legal description. They have their system. The Register of Deeds has their own. In most cases, they're going to match. They're going to be the same thing, but they do not have to always be the same thing. There could be a deed that's done that the Treasurer's office doesn't have, that didn't actually change ownership. And maybe it changed and went just regards to from a husband to a husband and a wife, and they changed the name of it from Lot 4 to Lot 4A. Well, they didn't change that with regards to the Treasurer's office. Where does this come up as a problem? Typically, when you're doing purchase agreements and you're dealing with realtors and they're putting those purchase agreements together, they go to the Treasurer's office, see what's owed for taxes. What do they put for the legal description of that purchase agreement? The legal description that the Treasurer's office has, which is often going to be wrong. So then you go through and you say, we're going to buy this particular piece of property, but you haven't actually described that piece of property. And most cases, it's not an issue because you go ahead, you close the deal, there's no big deal, it all gets worked out, you get the title search from the company, they go ahead, they prepare the deed, they have the right legal description. Nobody cares about this discrepancy between the purchase description, the legal description of the purchase agreement, and the one actually in the deed. What happens if your deal falls through? Remember when we learned in real property that those purchase agreements means that you can sue people on specific performance when it comes to it? And everything else? So what happens when you have a defect? Kind of a big boo-boo when it comes to what you put in there. You put the wrong legal description that goes forward with it. Kind of a problem when someone decides, say I'm selling my land for, $8,000 an acre, but then I get a great offer for $10,000 an acre. So I go ahead and I breach that purchase agreement. I got the wrong legal description that goes with it. Can I actually hold them to it? Because I didn't actually describe the property. So now I have a buyer who's ticked because they can't actually buy what they want, a purchase agreement that doesn't describe actual real property, and a whole big mess when it actually goes to court. I talk about this in the hypothetical, but it's a little bit of care on the front end when it comes to making sure that these things are done correctly. So just be aware of that distinction. Finally, down here, this is the key thing. South Dakota is a race notice recording system. Remember we talked about race notice, we talked about, these different types of systems that are out there. Who remembers that discussion from property and saying they're going, when does all of this matter in terms of whether or not our bona fide purchaser for value actually has knowledge about the transaction that's gone on and whether or not something's been recorded with the Register of Deeds office yet. This is where it matters with regards to when things get recorded. Our entire system in South Dakota is based upon the fact that persons have notice of stuff out there. We know that someone's always going to have notice if they actually know about it. But to have constructive notice when it comes to actually knowing about things there, it has to be recorded with the Register of Deeds and properly recorded. So keep that in mind. We now have, instead of going through, we have three primary ways of knowing what's against a piece of property. The most common example is title insurance commitments and policies. That's what not only most other states, but South Dakota has shifted completely to. We actually finally fixed it. One of the last places we had last year was when it came to partition actions under the code that still referenced getting an abstract for the court to do the partition. Well, no one does abstracts anymore. So we finally switched that to a title insurance commitment and policy. So we finally updated the code to properly effect that we do title insurance as our way to ensure that someone owns a piece of property. That's how most other states do it. The two other examples that go with it are abstracts and attorney's opinions. Abstracts are, like we talked about, South Dakota licensed abstractors. In other states, they have their licensed abstractors. They still prepare a full abstract. And what an abstract is, it's a summary and a listing of everything affecting that particular piece of title. It's basically just like our chain of title that we showed before, listing everything against a particular piece of property. An abstract does not report to say what effect each of those documents has. They're just listing what it is. So don't depend on the abstract telling you whether something actually impacts title to real property. What does that? That's the attorney's opinion. In other states where they don't have title insurance, or they don't use title insurance as much, they rely upon attorney's opinions. Typically, in an attorney's opinion, they've gone through, they've taken the abstract that either they themselves have prepared or a licensed abstractor has prepared, and then they compare that. They use their real property legal knowledge to write an opinion to say, this impacts title, this doesn't impact title, these are the things, and here's how you would fix it to remove something against it. That attorney's opinion is similar to what a title insurance commitment and policy says. Unless you practice in other states, you probably won't have to do an attorney's opinion. Now, having said that, two of the states that are in the minority when it comes to still using abstracts and attorney's opinions are our neighbors. Iowa is an abstract state. Now, if you go and practice in Iowa, there's still abstract companies that they prepare the abstracts, and they submit those to someone like Attorney's Guarantee down in Des Moines, who goes ahead and issues the attorney's opinions with regards to insuring that property. Iowa has gone so far, they have actually outlawed the practice of title insurance in their state. It's a rather extreme opinion that I'd be considered a criminal when I go down to Iowa to practice title insurance. Though they do allow you to use out-of-state title insurance companies to write title insurance policies. So that distinction that they've drawn for themselves creates a real mess when it comes to it. Minnesota often uses still attorney's opinions. While they do have title insurance in Minnesota, and it's often used especially in places like the cities, a lot of rural attorneys throughout the state still depend upon and use the attorney's opinions. That if they, as the attorney for the client, they prepare the attorney's opinion, they give the guidance, they handle the closing, they take care of everything that goes along with it. So to show you an example as to what those look like. Yep. So page number 7 of the real estate packet we're going to jump to first. This is an example of an abstract that was prepared over in Sioux County over there in northwestern Iowa. So you start with a brief description as the legal description as to what they're describing, as to who prepared it. Then, they're nice. They went ahead and prepared our sectional design showing the piece of property, a GIS image or a Google Earth image in some cases, depending on how advanced they are. And then we get the start of our abstract, where we have on your stuff talking about what it is that they reviewed first. Then they get what's been filed against the property. So we start with the resolution that was done in 1979 filed by the local county commission with regards to it. Then we go forward, and there's easements that are done further back on the chain of title. A warranty deed, another warranty deed. See, they're showing everything that goes along the way here that's ever been recorded against this particular piece of property. So they give a brief description. When you see more lengthy entries down here, it's because they want to include something that was specifically included in the deed. When we talk about those reservations or creation of easements, the abstract is showing those along the way. You would find them if you actually reviewed the documents yourself. So in that sense, it's an awesome product. They're going through and they're summarizing the chain of title for you in great detail. So that way you, if you're doing the attorney's opinion, don't have to go through and do this yourself. You start getting into mortgages that are recorded against the property, showing those still of record. And we get releases that go with the mortgages. Affidavits in lieu of inheritance. Finally, we end up down here. We have our real estate taxes, where someone has checked to see what the current real estate taxes are against a particular piece of property. We end with the certificate. That certificate matters because it's the abstractor certifying that based upon their professional liability as a licensed professional in the state of Iowa, that this entire abstract is true and accurate, a reflection of everything that's been done against this particular piece of property. It's because of that certification, who it's done to, who it's in favor of, that can be relied upon as an accurate representation. And if there's something wrong, whether that's inaccurate, that they missed something, then you can go back against the abstractor because they certified it was correct. Absent something like a certificate, there's no privity of contract. They just gave you a search as to what it said. They gave you a list of the chain of titles. They didn't say or certify under penalty of law that it was 100% correct or accurate. So it's that certificate that greatly matters in terms of being able to rely upon it. The alternative example is here's what an attorney's opinion looks like. This one's prepared over in southwestern Minnesota with regards to the purchase of an ag estate by a co-op. Yep.
People out
Yep.
in our land are following their path.
Yep, I actually moved them down going forward. Page 19 is what we're turning to go along with it, folks. It shows that an attorney, in this case, I believe it was Don Clausen who prepared it over there, went through, took a look at the abstract of title, he certifies right up here, and here's his view, that there's currently no mortgages against the property that impact title. A listing of the easements that are against the property that go with it. The permits that have been done, typically for your farm operations, especially if you have large-scale confinement operations, you have to get specific permits from the county and other regulatory authorities. Those are going to be recorded in the land record too. You have current real estate taxes. You're going to have delinquent taxes, if any, special assessments that go with it. Then finally we end up with number 9. Documents needed to transfer property, stating what needs to be done to complete the transaction. This is the attorney giving their opinion as to how you would actually complete the contemplated transaction that the purchase agreement describes and what steps are necessary. The end, standard exceptions, other language that they put forth with it, to where we finally get on page 23 where they sign off stating that this is a true and accurate description summary of title. So that was the abstract and the attorney's opinion. They're semi-related to each other. You're highly unlikely to see one in your South Dakota real estate practice. What you're more likely to see is this, page 25 for your documents. This is an example of a commitment for title insurance. This one, as I've stamped on there, for example purposes only, so that way no one can pretend to rely upon it as a legal contract. Let's flip back for just 1 second to move forward. We look at the fact that title insurance policies and commitments are insurance contracts. The same way that you have an insurance contract with your healthcare insurance provider that says, according to these certain terms, we will provide you coverage and give you insurance with regards to it. The title insurance commitment is the initial contract offer, saying that we will provide title insurance to ensure that you own this real property and defend you in certain cases, provided you comply with these terms. And how does it do that? It describes a particular piece of property, a particular person who's going to own that property. Perhaps a particular lender is going to give a loan on that property. And those are the parties who this insurance contract is going to be binding upon. Always remember that the title insurance policies and commitments, just like any other type of insurance contract, is specifically going to list what is covered and what is not covered. When we talk about the not covers, I'll show you in a second, that means special exceptions, things that otherwise would be covered except for the fact that they're accepted out of the policy, and those things that are general exclusions. Those things that by the very nature of the insurance contract are not covered in any way, shape, or form. Sure, we can take a brief break for going through stuff.
Yeah, 10-minute break. Want to be back at 5.
All right, thanks everyone. Where we left off right before we took a brief break was we were on page 25 with an example as to what a title insurance commitment looks like, where we talk about the fact that it's an insurance contract between the title insurance underwriter, the insurance provider, and the proposed insurance, the new going to be owners of the property and perhaps the new going to be lender associated with it. You'll see there's first just a standard boilerplate terms and conditions found on the first page and the second page, and then we get to page 27, where we have what's called Schedule A of the title insurance. Schedule A is important because, as we discuss up there, it's going to tell us all the relevant, important information for who the parties are for the contract. Specifically, we're going to list in there the who, the what, the where, the how much. What I mean by that is we go down in order. We start with number 1 on page 27. We have the effective date. That effective date means the date through which the search was done. Anything that's done after that effective date is considered basically a post-search matter. It's not going to show up with regards to it. In between the time that the title insurance commitment is issued and the actual transaction closes, that's the gap. In the title insurance world I deal in, that's what we're really afraid of. We're afraid of the gap unless we have an exception because we don't know what's there. That's what updates to title searches find for us. Examples, there's a lot of bad people out there in the real estate world, especially in other states, who made their practice prior to the real estate crash of filing things during that gap period, where they know that a piece of property is going to be sold and there's a $300,000 piece of property. And in between, they'd slip in a $400,000 mortgage during their gap period and surprise, you need to pay it. Or if you don't pay it, then it's a mark on title that has priority over the new mortgage, and then they attempt to foreclose against it. So anyway, just be aware of what that effective date is, because that's what the date of the search is going to be through. Then we have the policy or the policies to be issued and the amount of coverage in number 2. Specifically, we're talking about who the proposed owner is going to be, or who the current owner is, as if it's just going to be a refi, as well as who the lender is going to be and whether or not they're going to get standard or extended coverage. That matters for whether or not there's standard exceptions that are going to be included in that or they're going to be deleted. Then we have that amount of coverage that's listed there along with it. That tells you how much the proposed insured amount is going to be for. Under number 3, we have the estate in real property that's going to be insured. In most cases, it's fee simple, but it doesn't have to be. It could be a contract for deed, Ben D's estate. It could be a life estate. It could be a leasehold estate. That tells us what we're going to be insuring. Under number 4, we have the title. Who is entitled to this particular piece of property? That's the current owners with it. And then number 5, as you see down there at the bottom on page 27, we have the land referenced. That's the legal description. Where are they taking that legal description from? From the prior deed in the chain of title. That's the legal description of their property. This is, remember when I talked about before, people screwing things up and using the wrong legal description? It is hopefully by the point in time we get to the commitment where someone has actually searched and found the last deed of record, they will insert that correct legal description in there. And hopefully, I'm crossing my fingers for those of you who can't see right now, hopefully that process has gone through So that way when they draft the deed for the new transaction, they're using the prior legal description, because when you change the historic legal description, bad things can happen. We get on to Schedule B. This is where we're going to have our general exceptions that are listed there right away on the top of page 28. And then we get under subsection C of Schedule B, the special exceptions. These are things that they're specifically not including as part of the policy. We have examples such as real estate taxes, as you see there under number 1, existing utility easements that they're not going to be covered in our policy. Then we also get currently under number 4 on page 29 an example of a mortgage that's against it. They're going to take exception to other things that are currently against the property, or a judgment lien as we find in number 5. So that's an example of what a commitment is going to look like. You get the commitment. You also typically have requirements. Those requirements are how to get rid of some of the special exceptions. Some of them won't go away, but an easy example. How do you get rid of a special exception for a prior real estate mortgage? You get a satisfactory release for it, which should make sense. My wife and I sell our property to someone else as part of that process so that they can get free and clear title because I'm giving them a warranty deed. I need to pay off my existing mortgage or get a release tied with it. So it's going to show up as an exception, as we see here in the commitment, and hopefully if everyone's done their job correctly, it's going to disappear, be removed, because it's no longer an issue when it comes to the final title policy. So that was the commitment side of things. When we jump on over, we see that we have, just as a brief wrap-up, we have the general exceptions. They're always going to appear in standard coverage insurance policies. They deal with things like boundary disputes. Unless you get a survey and we're removing the general exceptions pursuant to extended coverage, we're not going to cover if you have a boundary dispute with your neighbor. That's not typically what title insurance is for. We also have those special exceptions, like we talked about, things that we're taking exception to because there are currently issues with regard to the property, and because they're of record, we're not going to insure them. Most commitments are also going to include a section, like we said, about requirements, the steps taken to remove them. We then move on to the actual title insurance policy. If we look to page 30, we have an example of a policy jacket. The jacket, just like you have your jackets for other types of insurance policies that are out there that contain the standard terms and conditions. Page 30 shows a standard jacket with regards to an owner's policy, which details all the way through what the standard terms are, what is covered, what is not covered, what's excluded from coverage. Examples would be zoning and police powers. Title insurance does not deal with your local zoning ordinances. We don't get involved as to whether or not your house is within 5 feet of the boundary line, thus violating local zoning provisions. This is what it deals with. Those terms in the jacket are also very important if you ever have a title claim. Why do they matter? Because it's the contract between you and your insurance provider. And pursuant to the terms of that contract, it details how claims are going to be resolved. Some people just assume I have a title claim. My insurance company pays me money. That's how it works. No, it's the resolution process that details what's going to be done to either defend you if someone's claiming ownership of your property, to clean up a prior defect in your chain of title, or if we ultimately can't do anything, then how we're going to pay according to the policy limits. So very important, if you ever end up in a situation where one of your clients does have a title defect and they have title insurance, to review the title insurance jacket, the full thing that goes with it. So when you're dealing with things, to make sure that everything's being done according to the terms of the policy. When we look back to our examples, we're going to see, flipping ahead, flipping through the policy terms, we end up back on page 34. Hey, it's Schedule A again. It looks kind of similar to what we had before, except a few things have changed. The transaction is closed. So instead of an effective date of this going through, middle of March, we now have an effective date of February 11th at 11:45. Why did they pick that exact specific time? Perhaps that's the date and time that the mortgage and the deed were recorded. They take that as the effective date, as the date of recording, they plug that in there, or some date immediately thereafter. We have under number 1, under Schedule A, we have our new insureds, not proposed insureds anymore, the actual insureds who are listed there. That means that Mr. and Mrs. Smith have completed the acquisition of the property. Up there at the top, we have the amount of the insurance. It's not the proposed amount or amount of coverage. This is the actual amount of policy coverage that they now have. We have that they now own this in fee simple. That title is vested in Mr. and Mrs. Smith, and the legal description remains the same. We get our schedules showing everything, our general exceptions, since they only had standard coverage. Those exceptions remain in the final title policy. We have the Part B listing the things against it. Instead of what was item number 4 before, which was the prior mortgage, on page 35 we see down there a new mortgage that was recorded on February 11th at 11:45 a.m. It's the new mortgage that's being insured as part of their acquisition of this property. It shows up as an exception on the owner's policy because it's an exception to their ownership of title. They have voluntarily agreed to encumber their fee simple interest by that mortgage. Why did they do that? Because they wanted to buy the property and they needed a mortgage to do it. So you'll see that as on the owner's policy. We jump ahead to page 36, we get the standard terms and conditions for a mortgagee or a lender's policy. Fairly similar to the owner's. There's a few distinctions there because they're not actually the owner of the property. They don't become an owner of the property until they go through the foreclosure process. But we get on page 42, we end up here with the Schedule A for the lender, which still is showing the name of the insured. Wells Fargo, the lender who lent the money on this transaction. It shows under number 3 who the owners are, Mr. and Mrs. Smith. Has under number 6, there's a standard set of endorsements that lenders typically get. None are marked here because none are included. Then we end up on page 44, the mortgagee policy, things that they're taking special exception to. Taxes, existing utility easements, an access easement, uniform covenants that go with the property. But what's not shown here? Their insured mortgage, because it's not being a special exception to their policy. So gives you some idea as to how the process works from start to finish. Any questions before we go on with regards to this idea of title insurance commitments and policies? I want to make sure that everyone's on the same page because when you're reviewing them, that's what you're going to be reviewing for things that are against someone's title as they're getting title work. Yes?
I just have a question with title insurance. Is that usually like a term thing or you pay once and like that's it? I'm just not very familiar.
Sure. Great question. When I talk about an insurance contract, I made it probably seem like it's like any other type of insurance. Title insurance is the exact opposite of every other type of insurance you have out there. And what I mean by that is title insurance is a one-time premium that's paid with regards to past defects to your title. You are basically insuring against what was against the chain or against someone else claiming ownership over your property. Unlike say your homeowner's insurance. You get your homeowner's insurance at the exact same time, both because it's good for you and because your lender requires it. So out of nowhere, you know, your neighbor's playing around with a bonfire and your house catches on fire. It happens after you've acquired ownership. Your homeowner's insurance during the effective coverage covers that, pays for it. Title insurance deals with those prior defects to affirmatively state that as of that effective date, you own the piece of property that you own. There's not some continuing premium that's necessary to continue that coverage. Hopefully, now this is from my underwriter's hat, our title insurance issuing agents have all done their jobs and they've shown everything of record. So what is it protecting against? Well, it's protecting against everything of record. So we got no issues there. We've shown all that. It's things that aren't of record. Some ancient person, you know, Mr. and Mrs. Smith's long ago predecessor in title thinks that their grandkids actually own this property, that, you know, their grandparents included in their will that should have passed to us. Now they're saying they show up on the door, knock on your door and say, hey, by the way, give us our house. And you go, no. Well, what are you going to go to law, go into a court case against them? Sure, but that's what you also have title insurance for. That now your title insurance company is going to represent you for defending your ownership interest that goes along with it. It also matters for in terms of lenders. You typically are required to get title insurance for purposes of getting a mortgage on your property to make sure that the lender is in first position, that no one else can foreclose against them. So that's how it works with regards to compared to other ones. Any other questions on the title insurance side of things? Hopefully that explanation kind of makes sense. I know it's different than what we typically think of that goes along with it. Be aware that we talked about abstracts, we talked about attorney's opinions, we talked about title insurance commitments and policies. There's other types of title searches or non-title insurance products out there. We typically, most of our South Dakota offices, they call them E&O, error and omission reports, where they're going through and they're going to pull the deeds that are of record against this property. They'll give you a copy of that, but they're not putting their abstract or seal on. They're not stating what these are, that these are the only things out there. They're not stating that these impact title in any way, shape, or form. They're basically leaving it for you to figure out. Those searches and reports are just what they state that they are. They're a list of the records against a particular piece of property. They do not, as that bold part, as that capitalized part down there says, do not include a determination as to the impact as to what each record instrument has on title. Don't rely on them as such. Don't assume because you have a title search that's the same thing as a title commitment. That title search is not going to guarantee you to a title insurance policy later on. It's just that, a search as of that date and time. It's only a title insurance commitment that as long as you follow through with the terms and the conditions and the requirements that get you that final title policy that protects your property interest. Sometimes you'll see things like title searches when it's an auction company, that they're going to go ahead and sell off some land. They'll get a title search. They won't get a commitment because they don't have a proposed owner yet for it. So if you're going to go through and actually get title insurance later on, you need to get the commitment and then the final title policy that goes with. So if someone is bringing you a title search, that may be great for showing you what's recorded against the property, but you can't rely upon it the same way you would for a commitment or anything else. This one's really useful, the recording requirements associated with it. SDCL 432823, that's a really important piece of code that's out there. Why? Because it is the guidelines. You must comply with it in order to record something with the Register of Deeds office. Failure to comply with the provisions of it means that they can reject it for recording purposes well within their rights. I'm going to state something that probably the Register of Deeds don't want to hear. They miss things all the time. They record all sorts of documents that don't fit the compliance of SDCL 432823, and that can cause problems later on. When I talk about those requirements, this is one of those few times where your margins matter. I've gotten into a dispute with the Register of Deeds down from the Ozarks in Missouri with regards to whether or not 3 inches meant 3 inches when it came to how much space was at the top of my document. Do make sure, err on the side of caution. If it says that you need to have, at least 3 inches at the top, maybe make it 3.5 so you don't get it back. It's real annoying when you send something time sensitive down to be recorded and you get it back 2 weeks later saying that there's some reason why it couldn't be recorded. That means there's that much longer that you're losing when it comes to the race notice statutes. So make sure that your paper size is between 8.5 and 11 and 8.5 by 14. Letter size to legal size. If you're going to be recording something larger than that, you may have problems. The only things that typically are recorded that are larger than those dimensions are plats for like a subdivision, things like that. And then the surveyor typically will take care of getting that recorded with the Register of Deeds. Make sure you're using at least size 10-point font. Don't try and, squeeze it on there to save the recording fees by making it 8-point font because you won't be achieving anything. It won't be recorded. White paper only. So I don't know of anyone who's copying things on their blue paper to take to the courthouse, but just be aware of that. Make sure you keep that blank space at the top of the first page. That's really important because that's where they stamp their recording information. And that's where it's kept with regards to it. We'll see in just a second what that kind of looks like. When I say the left side, what I'm referring to is the fact that of that 3 inches, the left side is typically where the attorney who prepares it stamps their information, their client's information. Once the Register of Deeds has recorded and indexed a document, they return the original to the party. We also have the right side, which is where they put their recording information for tracking through. And then right below that, typically people put the title of the instrument. The title does not control what type of instrument it is, though. It's the actual language included wherein. So, impact of not complying. It means that it may not be recorded. It means that you send something, you get that deed recorded. It may not actually be recorded. It may be rejected and sent back to you, which means Someone else could record a deed during that time claiming ownership to your property and that you'll lose the race notice. Some other lender can record their mortgage and actually get first position even though you submitted yours first. So be prepared to make sure that you comply because it can screw things up later on. Let's take a look quick at page 45. This right here is an example as to some old historic styles of deeds or how they index deeds for the short form with the Register of Deeds office. Pretty simple. Just list who the grantor was, who the grantee was, list the legal description, list when it was done, and then has in the middle of the page here the notary acknowledgement that was done with it. You know, half a page right there, they've covered everything that you need to convey real property in South Dakota. Now, we don't use these short forms as much anymore. Instead, we jump ahead to page 46 as to an example as to what a modern deed looks like. This is a modern warranty deed that was done last summer, showing that we have DLT Development Inc. as the grantor, specifically identifies them, identifies the consideration for a consideration of $1. We typically just put $1, even though that's not the actual total amount. The certificate of real estate value matters for determining what that total dollar amount is. Grants, conveys, warrants. Hey, that's our magic warranty deed language that we're going to talk about. This property too, Mr. and Mrs. Moe, they're the grantees. Gives their address to specifically identify them. What are they granting? The following described real estate. Lot 9 in Block 2. So we list that there, gives the date, has the signature of the grantor. We get down to the bottom of that page, we see we have our acknowledgement stating that so-and-so personally appeared at DLT Development, known or satisfactory to be the person whose name is described in the instrument, acknowledged and executed the same therein. Signed and acknowledged by our notary public, Ms. Kara Lee. So, gives you an example as to what this looks like for a modern deed that goes with it. We have specifically here on the next page, on page 47, our acknowledgement block that specifically identifies that it's Dale Christensen, who is the president of DLT Development, Inc., who signed. Good acknowledgement there from our notary. That matters because when we talk about acknowledgements, acknowledgements are specifically stating that who the person was who executed the instrument. That matters because it takes care of the issue of identity. Because we have a notary public officer who's gone through and appeared, they've gone through and they have made the determination saying that I know for a fact. How do they know it? Typically they looked at somebody's driver's license and compared the picture. That so-and-so appeared before me and that this was one and the same person. All right, that's great. Identity is awesome. But we really care about the fact that acknowledgement's being taken because without an acknowledgement, it fails to impart constructive notice of the statute. So just because someone has recorded something at the Register of Deeds office, it's actually not providing constructive notice to anyone else unless there's an effective acknowledgement. Defective acknowledgements prevent constructive notice from being given. So, you know, you record that mortgage, that's the bad acknowledgement with it. You think that's being given constructive notice to all third parties. It's not. We have to wait at least 10 years for that defect to be cured. In that interim, anyone else who records something is going to have priority unless they had actual knowledge, actual notice of the instrument that has the defective acknowledgement. So it's very important that you have the right acknowledgement blocks. On their SDCL 18.4 and 18.5, our South Dakota legislature has done a good job telling you what acknowledgement blocks should look like for individuals, for married couples, for persons acting in capacity like presidents, members, trustees. When you're out in practice, go to SDCL 18.14, 18.5, 18.4 and 18.5. Look those things up for your specific situation. Copy down an example of a good notary acknowledgement block. Use it from there on out. Don't reinvent the wheel and think that you should create your own notary acknowledgement block. This is one of those times where copying other people's work is a good idea when it comes for it. If you are the notary public certifying your acknowledgement on it, be sure that you're using the right notary acknowledgement block for the situation. I say that because there's lots of dumb people out there, and by dumb people I mean big banks. When you're going through and you're doing a closing transaction, Wells Fargo has put together a notary acknowledgement that's the same one they use in all instances. So they've sent you a personal acknowledgement block, even though it's an LLC that's actually mortgaging the property. Is that going to be a good acknowledgement because it's the wrong block? No, it is not. Thus, it's on you as the officer taking the acknowledgement to fix it, to put the correct one in there, to ask for a corrective one to be done. So be aware and review that. Be also aware that the capacity of the person is listed. If we have a married couple, make sure that states husband and wife, married to each other, things like that. If we have someone who signed off as an officer of a company, state the capacity. Failure to include that capacity means it's defective, so be aware of that issue. Remember I talked before about going to the Secretary of State's website for taking a look? This is where it matters, for checking to see who is listed, what the name of the entity is to make sure that the acknowledgement block is correct. You probably remember for property, a conveyance means the transfer of property from one person to another. The person who's transferring the property we call the grantor. The person receiving it is the grantee. For the conveyance to be effective, we need to actually have a grant or conveyance. We need that conveyance language. Grants, quit claims, warrants. It needs to actually be delivered and accepted by the grantee. Recording is not required for the conveyance, but recording means that we get to presume that acceptance has occurred, that they've actually received, this because they're going through and they've recorded against third parties. And remember that generally the grantor can only convey whatever they own in the property. You can't convey that which you don't own. You can do that to create a chain of title for it, but typically speaking, you're only conveying that interest that you actually own. We also have affidavits that are recorded. Generally speaking, affidavits have limited value though when it comes to real estate transactions. While you could record an affidavit as long as it meets the recording requirements, it's only going to be effective for that which it's authorized to do. Title Standard 7-09 details when you can use an affidavit. It's for minor defects in title, not major defects. It's things like confirming that people are one and the same, that John S. Smith and John Smith are one and the same person, thus alleviating any confusion. That if they were married, who they were married to, if they weren't married, that to make that clear of record. As to whether or not a piece of property was homestead property, as i.e. where they lived and their homestead protections would go for it, as well as ambiguous non-material defects. Remember, we don't care about the address, but oftentimes we'll put the legal address, we'll put the street address in a particular piece of property. So if they put 1709, it was supposed to be 1707, we can correct that with an affidavit. As well as marketable title, affidavits of possession. We'll get there in the end. All right, here's the main types of real estate transactions that are out there that you may have to prepare real estate documents for. Most common is purchase agreements with regards to starting the process. If you are going to act as the realtor, you're acting on your client's behalf so they don't involve a realtor. You'll prepare the contract between the seller, the grantor, and the buyer, the grantee, detailing the terms of it. Please be sure that you take your time preparing them. List things like purchase price, closing dates, how things are going to be split and prorated, who's in charge of what. You're creating a legal contract the same as any other legal document that you're drafting. Give it the time and care that it deserves. Most people do not give it that time and care. They just use a form, they fill in the names, and they call it good. As I said before, this isn't an issue in 99% of cases because people close and everyone walks away happy at the end of it. Don't have it be the situation where your client, something happens, and they actually have to go to court, and because someone didn't take the time of the purchase agreement, there's now an issue with regards to it. We have deeds. Deeds are that conveying instrument. We have three primary types. Warranty deeds. I have listed up there the common warranties of title. Remember when you studied those in real property going, when in the heck am I ever have to know about the warranty of quiet enjoyment specifically for it? We don't really care about so much, but if you're doing a warranty, you're giving those warranties. So if your client doesn't want to give those warranties, don't use a warranty deed. By them saying the magic words of grant, warrant, convey, you've given them each of those warranties of title pursuant to our understanding. Who knew that the little word of warranty contains so much that goes along with it implied in it? So be aware that anytime you're doing a warranty deed, each of those warranties of title are being used along with it. We already saw an example before, that modern example on page 46 and 47. as to what a warranty deed looked like. Some other examples. Go with it here on page 48. Remember when we talked about our chain of title with the Hills and them screwing up property by deeding to Israel's Covenant Church, a non-entity that didn't exist? To try and clean it up after the fact, we've had them go through and deed out Thomas Hill individually as the owner, deeding interest in that property because it was a void conveyance before, so no title actually passed. Thus, it still remained vested in Mr. Hill. So he goes ahead and he, in January this year, did a warranty deed to go along with it. Our next type of deeds are grant deeds. Grant deeds are basically the halfway point. They're not a quitclaim deed, but they're not a warranty deed. You're only giving specific grants of title that you're specifically stating. The most common example of a grant deed is stating that the grantor, the current owner, states that they have been the sole owner of the property and that it's them alone who's owned it, and they're warranting against their own acts while they are entitled. Who uses grant deeds? Typically, it's banks after foreclosures because they don't know the entire chain of title. They don't want to be on the hook for what their prior borrower did or their predecessors in interest. So Wells Fargo will go, I will warrant only as to actions that Wells Fargo has done while they were entitled to the property. That's when it's used. Our final type is quitclaim deeds. A quitclaim deed basically is just saying, I quitclaim, using that word quitclaim in there, release, remise, are giving you any interest I have in the property. Whatever that interest is, and I don't warrant you that I actually have an interest in that property. It's basically worth the sheet of paper that's on. So if I actually had fee title and I owned everything in the property, I give you a quitclaim deed for it, I've given you my interest in that property, great, you now own 100% of it. Or if I actually had no interest whatsoever, guess what you now have pursuant to that quitclaim deed? No interest in the property whatsoever, because I've given you all that I had at that particular time. So you're basically conveying only whatever right, title, and interest you have as of the date of the deed. There's no after acquired title unless it says otherwise. So on a warranty deed, I deed you my property. Later on, pursuant to some screw up, I come back into title. Pursuant to the warranty of after acquired title, that automatically passes by operation of law to you. I don't have to record a new deed. A quitclaim deed, on the other hand, doesn't have that warranty. Thus, I come into title later on. Do you get that title automatically? No. Now I own an interest in that property again. And the only way that you can get it is if I quitclaim or deed it to you again. So typically, you're only going to use quitclaim deeds in a situation where someone doesn't have a real interest in the property, but you're cleaning it up. They don't want to warrant. So it creates a break with regards to these warranties of title when they're used. So be cognizant and be aware as to what you're going to do when you're doing it. We see on page 49 an example of a quitclaim deed stating that Mr. Strawn, who owned property down here in Clay County, hereby agrees to convey and quitclaim to Geraldine Turner this particular piece of property. This was done to clean up an issue where Charles's sister, who was a 50% owner with him in the property, had deeded out 100% interest, but she forgot to get her brother to sign off on it all the way back in 1990. Now we have to fix it today. He doesn't want to give a warranty because he has no clue what's gone on with that property since that time, but he will go ahead and sign with his signature there. CS, he'll sign and state that he'll quitclaim his interest, thus terminating any interest he has in the property as of the date that this was done, as of December 22nd, 2015. So there's an example for you with regards to a quitclaim deed. We also have what's known as trust deeds. Typically, they're used and utilized by trusts. While it says trust deed on it because it's being done by a trust, it's nothing different than a warranty deed or a quitclaim deed. That title doesn't change it. It's the words contained in the deed that matter. The trust deed to be aware of, though, that they're going to say that so-and-so is signing as trustee on behalf of the trust. That capacity question that once again comes up. So you do not need, I've gotten this question from attorneys and I've seen it in practice, people do trust deeds, they label that when the grantor, who's an individual, deeds it into the trust. Why the heck are you doing that? It's not a trust who's in the chain of title in any way, shape, or form. It's when the trust, who's the owner of the property, is deeding out the property that you see a trustee or a trustee that's used. An example can be found, a redacted one that was done recently on page number 50, saying that so-and-so, the blank trust with the grantor as trustee of such a trust, is the one who's going to go ahead, grants, conveys, and warrants. It's a warranty deed. So just because it says trustee's deed up there doesn't change the fact that legally speaking, it's a warranty deed. And we have our acknowledgement down here, once again, where we're stating that so-and-so is the trustee of such a trust, and that's the capacity that they appeared in. When we deal with trusts, we also have certificates of trust. Those are recorded in the land record. Certificates of trust are necessary to establish who has authority to act on behalf of the trust at the time that the trust acted. It's a simple form. If you go to SDCL 55.451.3, awesome citation that goes there. That's why I put in the PowerPoint. That's where the form is at. This exact form is online for you to take. Use it. Fill it in the blanks. Stating that so-and-so, that such and such a trust owns such and such piece of property, that this particular person or persons is trustee, and as of this date, the date of the certificate of trust, they were authorized to buy, sell, convey, encumber real estate. That's necessary to make sure whoever acted on the trust has authority. We also have personal representatives deeds. Similar to the trustee's deed, someone else is acting on behalf of the estate. You're going to see a PR's deed when someone has died and that their PR, their personal representative, has been appointed in that court case. From that, we're going to see that the PR is hereby authorized to sell property. They're going to do a PR's deed. It's going to be the same thing. It's going to be a warranty deed or a quitclaim deed. Look at the language contained therein. It's used to convey property out of the estate. Prior to the PR being authorized to do that transaction, though, they need letters of personal representatives that are issued in the court case, saying that so-and-so as personal representatives hereby authorized to carry on and convey this property in general to basically wind up my estate. Those letters must come from a South Dakota probate court. Where this matters is with regards to out-of-state probates. Under our statutory scheme, and while it's confusing because it talks about out-of-state ancillary probates, you must start a probate in South Dakota, specifically ideally in the county where the property is located, to convey real estate. So just because someone's dad dies over there in Minnesota and they do a probate there, now they're going to sell property that they own, maybe some old ag land that they inherited from their parents back here in South Dakota. You can't rely upon that out-of-state probate. One must be commenced within the state of South Dakota for that to be done. You need letters of PR to be issued by a court of competent jurisdiction in this state. We'll see on page 53, an example of a PR's deed. Back to our Hill example, Thomas Hill was appointed as the personal representative of his brother, Richard Hill, who was the co-owner of that property. Richard died. Thomas signs a PR's deed deeding out his interest being Richard's estate interest in that property that was described therein. We have our acknowledgement done that Thomas Hill personally appeared, described as the personal representative of Richard Hill's estate. Good job there with the acknowledgement. Finally, here's an example of what letters of personal representative look like on page 55. Similar to any other court filing, we have our docket, we have our case number up there. That's certified by either a circuit court judge or a clerk of court stating that these letters have been issued in this probate authorizing this person to act as personal representative with all the powers that the probate code under 29A entail that person. So you need to record those letters in the land record prior to or in connection with the transaction to give third parties notice with it. Easiest way to do that if you're doing a PR's deed, attach a copy of the letters with the deed and record all of it together. That's the easy way to make sure that's taken care of. We also have powers of attorney. It provides who is authorized to act on someone else's behalf. For someone to be able to convey real property, you must state that in the power of attorney. You can't just be implied. So we typically see them more and more because people don't want to show up to closing. Elderly couple, they're going to buy and sell property, but they're vacationing down in Arizona. They're not going to attend a closing that occurs in Sioux Falls. So they execute down there or before they leave a power of attorney that appoints their attorney, their children, one of their friends to go there and sign on their behalf. If you're drafting the power of attorney documents, be sure to include that they're authorized to do any and everything associated with real estate: buy, sell, convey, encumber, mortgage, rent, lease, sell, exchange. Because if you don't include those things in there, they may not be authorized to act on that behalf. So be aware of that. That middle portion right there, it does not work to give or allow someone else to act on your behalf in some other capacity unless it's done. I have seen more and more dishearteningly recently where someone has done a power of attorney to someone else to say, well, they can act on my behalf as the trustee of the trust. No, they cannot. How does it work for you to use a power of attorney document to appoint someone else as trustee unless the trust has done so? How does it work for me as the member of the LLC to say that for Marilyn over here, that she gets to show up because of the power of attorney and now she gets to act as a de facto member, even though the rest of the LLC hasn't voted on it? That doesn't work from a capacity standpoint. So think about those things. You can only give someone a power of attorney to be your attorney in fact if you have the capacity to do so. So think about that when you're reviewing the documents and don't just assume, well, I'm gone, so I'm going to have my daughter Sally sign all my stuff on my behalf. While that may work individually, it doesn't work with regards to overall capacity. We can see on page 56 an example of a limited power of attorney. More and more with regards to big banks, they use power of attorneys to allow each other to act on their behalf. This is part of their brilliant system when they created the Mortgage Electronic Registry Act, MERS, that allowed them to rapidly sell and transfer mortgages, which allowed them to bring about the collapse of the housing economy, but that's a story for a separate day, that they allowed themselves to give each other these limited power of attorneys to act on their behalf for their transactions. When it comes to it, we see that in this particular case, Wells Fargo out of Nebraska has hereby given its parent, Wells Fargo NA, the ability to sign and do anything on its behalf for a specific limited period of time. So this is an example of a highly complex one. More often we'll see where we appoint, mom and dad appoint their daughter to sign their documents on their behalf because they're not going to be there. We see on page 57, a quitclaim deed that was done. It's done on behalf of Marilyn Palmer and Juliet Palmer, where they're going to convey to Diane Palmer, the trustee of the Palmer Family Irrevocable Trust. All good. Then we get the signature line at the bottom of that page there where we have Marilyn Palmer signing as the grantor. But what about Juliet Palmer? Well, we're going to have Marilyn Palmer as attorney in fact for Juliet Palmer sign it, a limited power of attorney. Okay, that may work if there's a recorded power of attorney to that effect. In this case, there was not. Then we get on page 58, the acknowledgement. Let me scroll down. Where it says that personally appeared before me, Marilyn Palmer, an individual. Where's the reference to the attorney in fact? Where's the reference to Julian Palmer's? It's a defective acknowledgement because it's not recognizing the capacity of the person doing it. Thus, this deed, which met the recording requirements, as we see on page 57, was actually recorded in the Spink County Land Record, is recorded. But because it's a bad acknowledgement, does not provide constructive notice. And it won't be fixed for 10 years on, so until December 10th, 2025. So kind of a problem when it comes to it there that could have been avoided by carefully reviewing the capacity issue associated with the parties. We also have, if you're preparing the purchase agreement, you may also prepare a bill of sale. A bill of sale is similar to a deed, but just for personal property. You're typically going to prepare just a one-page document stating that so-and-so conveys this particular piece of art or this car to someone else. There's standard forms that you can use with it. Sometimes we'll see real estate deals that have a deed or a purchase agreement that goes to completion, a bill of sale for selling the washer and dryer, the refrigerator, the shed that's in the back of the house. So if you're preparing something and there's going to be personal property transferred to, be sure you prepare a bill of sale as well. They're not going to be recorded in the land record, but showing the completion of the transaction between the parties. You'll also have the certificate of real estate value. For any transaction, unless you fit an exception, you must fill this out when property is conveyed. This must be done and then sent in to the Secretary of State and the local Register of Deeds so that they can assess the taxes that need to be paid upon that conveyance and also to show that it's happened. The nice news is that the Secretary of State's office and the Department of Revenue have a form. They give it to you. It's a PDF that you just need to fill in. After you're done, you can even submit it to them for going through the process, or it'll tell you where to mail it to. It also has instructions on page 2 for filling it out. If you are the one handling the closing on behalf of your clients, be sure that you read through because you are probably going to be the one to prepare the certificate of real estate value on their behalf. As we see on page number 59, here's what the one-page form looks like. It says who is selling property, who's buying property, what's the description of that property, what's the dollar amount associated with it, and do any exceptions apply therein. We see on page number 60, here's the instructions for helping you fill out that form. Be aware of it if you're involved in any type of the closing process. Make sure you're helping your clients fill that out and get that submitted. Do not fail to file that because that can cause all sorts of problems when it comes to the taxation and dealing with the state. We also have contracts for deeds or installment land contracts, similar to, I think you guys probably covered in property, where I can, instead of selling you fee simple today, I'm going to give you a property interest and you're going to make periodic payments to me. At the end of those payments, you're going to own the property. So what we typically, how we refer to people is the person who's the fee simple owner who is selling the property on a contract for deed. We call that the contract for deed vendor. And then when they agree to sell the property to someone else, the buyer, we call them the contract for deed vendee. As of the time that the contractor is entered into, the vendor still owns fee simple. They still own a real estate interest subject to the vendee's interest in that property. The vendee, we say, has an equitable interest in real estate. They can go ahead and, they could convey that if it's allowed in the contract. They can mortgage that vendee's interest. So it's a cool position for it. The terms of that transaction are to be governed by the actual contract for deed itself. If you're the attorney preparing it, you want to consider things like, is that contract for deed going to be assignable? Is that contract for deed going to be when it's going to be done in completion? Who's going to hold it? Who's in charge if there's a default? We have under SDCL 2150 an entire remedy provision to foreclose on contract for deeds, similar to how you'd foreclose on mortgages. Typically, to give third parties notice rather than recording the entire contract itself, we record what's called a short form contract for deed. It's just a one-page summary saying that a contract for deed was done between this person and this person for this particular piece of property. So it lets other people know about it.
I just have to let you know just about 5
Yep.
minutes, so I don't know.
Yep, we're going to get into the end quick. We also have leases. That's where you're giving someone some interest to currently use the piece of property for some period of time associated therein. The new type of deed that's out there in South Dakota is called transfer on death deeds. They're found in SDCL 29A6401 on. It works similar to a transfer on death bank account, which allows for someone to go ahead and as of their death, that's when the deed becomes effective. It's not effective until the point that someone dies. It's done by an instrument called a transfer on death deed. It has the same type of requirements as any other deed. You need to record it. It must be recorded before the transfer passes away. Then after they die, you need to record an affidavit, confirming death basically that goes along with it, as well as the state gives you a form to revoke them. We can see those on pages 61 on, have the examples of the statutory form. So if you're being asked to prepare it, just use what the state gives you for going through, for filling it out. So it's a new thing. We don't have too much yet with it. It's only been around for about 1.5 years. So some attorneys have been making great use of them. Some of them still haven't really heard about them. So we'll see more of them as we go forward, as some clients use it to avoid probate. We also have mortgages. Typically, you're not going to prepare the mortgage unless it's between private parties. It's going to be the bank who prepares it itself. That's the voluntary lien that the person's putting on their real property. That says that because I'm getting these funds, I agree to give you the position to foreclose against me to own this property unless I make my payments. If the owner defaults and they're going to foreclose pursuant to the ways with it, be aware that for a mortgage or anything else that you need to make sure that everyone is properly signing off on it to properly encumber it. There's other liens. We have personal money judgment liens. That's where, you go ahead, you don't pay your credit cards, they get a judgment against you. That judgment lien attaches to your real property. That's where we're going to find those in the clerk of court's office. Those are good for 10 years from the date that they're docketed or entered. And they can be extended or renewed an additional 10 years as long as an affidavit of renewal is done prior to the expiration of it. You can take a judgment in one county and go ahead and docket that in another county through a process called transcription of that judgment. So that makes it so that if there's a judgment in Minnehaha County, I can go and take that down here to Vermillion if I also own property here. We also have mechanics liens. Those are a specific statutory lien that's given under SDCL 44 that provides that if you provide work or materials for a property, you get a lien and you have 120 days to perfect that lien before you lose priority. Big deal when it comes to construction because any work a mechanic has done may have priority over the actual permanent financing mortgage, which can cause a huge problem. So something to be aware of there. You also have plats and surveys. We saw some examples of those before. That's where the surveyor goes out, they make the legal description for the property, they set the boundaries that go along with it, they show the boundaries that go with it, and that they show what the new legal description is. You need a boundary survey for the purposes of creating a plat. Nothing less than a boundary survey was going to create that. That boundary survey is actually going to show the actual dimensions of the property and any encumbrances onto and off of that property. So be aware of that. Avoid an example of what a plat looks like on page 63, where these guys have gone ahead and they platted a piece of property in section into these outlots. They did that so that way it was a bunch of siblings owned it, so one person now owns outlot 1, one owns 2, one owns 3. Helps for dividing up property interest. Properly done, you see on page number 64 all the signatures necessary for going through the process. Your surveyor, if they're doing the plat for you, should be the one to help out with it. On page 65, we see an example of what a mortgage inspection survey. This is the modern survey. I use quote marks right here. It's not actually a survey. It's just a drawing. It specifically says in this box down here at the bottom, this is not for boundary purposes and cannot be relied upon for anyone. This is just a general drawing of what this property may look like. Most clients and transactions are going to get this because they're required for their mortgage. It does not matter for title purposes. It's not a good title product. So don't rely upon anything that says mortgage inspection survey, mortgage drawing, title insurance drawing. It's not going to be what you're looking for. We have easements where we have dominant and serving estates. You guys have reviewed those. If you're going across things, be aware of the two different types of pertinent easements. Those are things that run with the land. They're going to be conveyed when you convey the property. Common examples are like access. If I don't have access, but I get access through an easement across your property, that's going to be an pertinent easement. You also have easements and growths. Those are personal easements, where let's say I give Marilyn an easement to use my property for hunting and fishing purposes. It's not going to run with the land except in very few circumstances. Easements and growths are not estates in real property. So when you're thinking about it, it's just a right. It's a license to use someone else's property. As always, that last line, watch out for merger. If the same person owns the dominant and the serving estate, those interests have merged. That easement ceases to exist. So that can be a big issue when it comes to your access easements where someone buys both pieces. Covenants or restrictions are private zoning. You're not going to see them too often with regards to the process going through, but be aware of them if someone's recorded them against property. Affidavits of possessions are super cool when it comes to South Dakota. SDCL 4330 says that if you have an unbroken chain of title for more than 23 years, you can record an affidavit of possession, just a simple affidavit that provides that by recording the affidavit, you hereby foreclose out any old defects older than 23 years old. So when we talk about, that maybe ancient interest that someone never deeded out the property in 1940, we can now use an affidavit of possession to terminate that interest of the prior owner. Not very many states have them. They're a very cool process, but be aware that they can't solve all issues. Like an affidavit of possession cannot be used to defeat an interest of an ownership of the state with regards to the property they're in. Common issues associated with it, homestead marital status, make sure that if someone is conveying property, that it's either, if it's their homestead where they live, that both the husband and the wife sign off on it. Or if it's not their homestead, that property cites that. This is because under SDCL 433117, failure to properly state or have everyone sign off on it means that the conveyance, the deed, the mortgage is void. Big deal there. Means that's a bad transaction. Doesn't actually work because of the protection homestead provides. Finally, if you're going to go through and create a plat, make sure that everyone has access to it. Some people assume that they show an access easement on the plat. Unless there's language creating it, it doesn't actually exist. Watch out for merger. Finally, correcting documents. You can correct minor defects through affidavits like we talked about, but if there's a material defect like a bad legal description, the lack of one of the parties being on it, you must re-record, re-execute, re-acknowledge, re-deliver the document by all of the parties. Don't just assume by crossing out the title saying corrective instrument and fixing it with pen and signing an initial to it, it fixes the problem. To correctly fix problems, you need to give it the same type of requirements that were done to initially convey it. Drafting problem, here you guys go. This is your guys' homework assignment. It's also going to be posted and listed on the website associated with it. We have a husband and a wife, Daisy and Donald Duck. I was just reviewing pictures of my nephew and went to Disney World recently, so I was in the mood. They just got a divorce. Now they're going to divide up property that each of them owns. It's your job to draft the deeds to complete this divorce. It's up to you as to whether or not you guys are going to do a quitclaim deed, a warranty deed. I hope, for my purposes, that I have given you the easiest drafting problem that you will have all semester. As you notice when you looked back on your title, I may have mentioned that there's some bolded items on here. These are examples of good deeds that people have done that are effective. Perhaps you should take a look at them when drafting your deed. As long as you comply with the recording requirements that are found previously, the pinch, the margins, everything else, and you perhaps use the magic language and acknowledgement blocks from before and apply your fact pattern, you probably will get it 100% right when it comes to it. The reason I gave you such an easy one is for this reason. Everything we talked about today applies to all real estate transactions. If you understand the basics, you'll understand the complex ones. It's important to get down the simple process because if you can't do the simple, it screws it up for everyone along the way. And I can tell you that there's plenty of people out there in practice, whether it's attorneys or parties themselves when they're doing things, they're not following the basics. And that's where issues arise. So hopefully that this helps and you guys will be able to go through. Please feel free to ask me any questions that you have. I'll stick around. There's business cards up there with my phone number and email address as well. Hopefully this has been helpful, enjoyable. I hope that all the examples help you going forward, and hopefully you guys have good luck going forward with your exams when you finish up your bar exam and then out in the real practice when it comes to real estate property. Thank you all so much for your time.